The community property question from February of 2001 is about as simple and straightforward a fact pattern as you could hope for. It is not, however, the easiest community property question you can hope for. As we'll see, there are a couple of quite technical issues present that, if you don't know going in, you'll know by the time you're done. Also, if you're one of those many candidates who's using this seminar as a way to learn community property law, this will be a highly instructive question. This also is not a racehorse question. You've got to really take your time, because we've only got 3 items of property, and although the analysis is a little intricate in places, and there are a couple of black-letter law rules that not everyone knows, basically, this question is just like every other community property question. We'll talk about the source, actions, presumptions, and we will reach appropriate conclusions. So take a look at the call of the question. We're being asked about a home, a mutual fund, and a cabin. Well, we know the structure of our answer already, but we don't know the content until we actually read the facts. So, please join me at the top of the question. Let's have a look. In paragraph 1, we find that this is a California domiciled marriage, and we also see that the husband, Herb, purchased the home in 1979, and they move into it in 1980. So, without even reading anything further, we can venture a guess that our answer to the issue about the home is it will be a community property asset. The husband may be entitled to reimbursement for his earliest contributions. We'll have a look. In paragraph 2, we learn a lot more about the purchase of this house. He buys this home for $50,000, $5,000 down, and a promissory note for the balance. At the time of marriage, the outstanding balance is $44,000, and during the next 20 years, they pay the note off. The fair market value currently, $200,000. All right. One other aspect of this fact pattern that makes it somewhat more difficult for a number of applicants is it's helpful to do a little bit of arithmetic to come up with a really sharp answer to this question. The math is not hard, but for some of you, it probably is. We'll have a look together. The bottom line that I have for you about numbers is this, and it's a point I've made elsewhere in this course. If you really are so phobic of math that you don't want to do any arithmetic under test-taking pressures, that's actually probably okay. If you can just set up the formula and assume the grader can do the math, you're probably okay. But if you, like me, are not afraid of a little bit of simple arithmetic, go ahead and do it. In paragraph 3, we find that in 1985, a few years after the marriage had started, the wife sells an original watercolor painting for $10,000. Well, her work in creating that painting is community labor, and so this painting is community property, and the $10,000 is community income. We see that Wanda and Herb orally agree that the $10,000 will be her sole and separate property. Well, we can stop right there. Here's where one of those little black-letter law details is being tested, and it's one that we have gone over in at least one other essay question in this seminar. Oral transmutations are ineffective after January 1, 1985, absent fraud or some other misconduct. But the basic rule is oral transmutations after January 1, 1985 are ineffective. Therefore, this $10,000 can't be transmuted orally, and Wanda's investment and the mutual fund all should be properly deemed community assets. All right, that gives us our answer to the second call of the question. Now let's look at the vacation cabin. In 1985, Herb and Wanda buy this vacation cabin on the coast for $75,000. They make a down payment of $25,000 with community property funds, and they both signed a note secured by a deed of trust for the balance. Title is taken as joint tenants. Shortly afterwards, in the following paragraph, Herb inherits a bunch of money from his mom. He pays off the note with inheritance money. That's separate property, and it will be subject to tracing. And then he sinks an additional $20,000 in separate property into this cabin to improve it. Its current fair market value, $150,000. Then in '01, Wanda initiates a dissolution proceeding, and we're asked about Herb and Wanda's respective rights in the home, the mutual fund, and the cabin. Well, here, as elsewhere, organization becomes the key to success. So let's have a look. We're going to follow the same basic format here that we follow everywhere in community property. So we will talk about the source, actions, and presumptions. And here, as often is the case, we will have internal organization for actions based on the actual facts of the pattern. We will use the facts as headings and then interpret those facts in the text of our answer. So, briefly, let's look at the outline. With regard to the home, the source is a $5,000 separate down payment. Actions, the community property payments, separate property payments before marriage, community property payments after marriage for 20 years, and the current fair market value. We will conclude that the house is a community property asset, and the husband could get a $6,000 reimbursement if to do so would be just. Remember, in community property, the judge, the bench officer in the family law court, technically is sitting in equity, and he or she can do pretty much whatever they please so long as they don't abuse their discretion and achieve a result that is, taken as a whole, equitable. So we move on to the mutual fund. The source of this fund is a $10,000 sale of a painting made by the wife during marriage. It's a community property sale and community property income. We focus on 4 different actions: the transmutation in 1985, ineffective; the $10,000 mutual fund taken in the wife's name, that's not dispositive; the note that the wife did not actively manage the fund, because that's one of the facts they give us, we deal with it; the current fair market value is $45,000, and we conclude accordingly. Finally, we move on to the cabin. The source of the cabin was a 33.33% down payment of $25,000. Then, again, we look at the actions and we focus on the facts. Both the husband and the wife signed the note. The title is taken as joint tenants. The separate property is used both to pay off the note and to add a room, and the final fair market value at the time of dissolution, $150,000. We conclude that the husband is entitled to a reimbursement. The rest is deemed community property. Okay, fair enough. It's very straightforward. It's not a racehorse like some of these questions are, where we've got 5 or 6 items of property to deal with. That means we have a responsibility to go in depth. That's why the outline is so fixated on the facts. Because with only 3 items of marital property, we really have to concentrate on the details. So, briefly, let's review the answer that I present. Here, up front, I choose to give you a model of what a proper introduction would look like if you really feel like you're going without a security blanket in leaving this out altogether. You know, my view is that it's appropriate to have an introduction when we're dealing with, say, a meretricious marriage, or we are dealing with quasi-community property. But in a straight community property fact pattern, like this one, I really don't think an introduction is necessary. But many candidates feel, because they've had it drilled into them for so long, that they must have some sort of quick introduction at least. Well, this is what I think it should look like. We lead with the facts. We indicate that this is a California marriage and that it will be governed by California community property law. Fair enough. Next, we turn to the home. And under source, all I am doing is reciting the facts that we're given, and I'm interpreting them. We move on to the actions, and here you can see that I do a little bit of math work as well as reaching a conclusion. I won't take the time to read it to you, but have a look. This is the sort of logical, factual analysis that always will win significant points on any essay question. Here, they give us a question with some figures in it, so I take the time to do the calculations, and the result is I award the husband 12% of the value of the house. That means $24,000. The remaining $188,000 is community property. A 50-50 split will ensue. Next, we focus on the mutual fund, and here, this is a fairly technical part, if you don't know this law about transmutation. Once again, this is a great excuse for doing an awful lot of practice essay questions. Because by practicing essays, you're going to see that they test this issue over and over again. This law was changed in 1985, and they're still asking questions about it in 2001 and 2010. Be prepared. Once we know the law, the analysis is simple. The source of the fund is a community property sale of a work of art made during marriage. We focus on the oral transmutation, and I point out, correctly, that had this incident occurred in 1984, there might be a very different result. But we're all taught about this change that occurred in 1985. And actually, I took the summer '84 bar exam, and we were all briefed very thoroughly about how the law was about to change, and they anticipated it being tested. So we focus in the second paragraph of actions on the fact that Wanda invested this money in her own name, but that fact doesn't change the essential nature of this property. The analysis under actions, I think, is instructive, both because it's very comprehensive with regard to the facts and because it's very clear about what the law is. So we reach a conclusion that becomes entirely predictable in light of the analysis. The mutual fund is community property. The oral transmutation fails, it's invalid, and there are no facts present that would justify awarding this mutual fund to the wife as her separate property. Finally, we focus on the cabin, and here there's another bit of black letter law that you will hardly ever learn by studying outlines, but you'll know it forever after you review this fact pattern. Let's carefully review this last issue in the fact pattern. We are analyzing the cabin. We start off with the source. So far, it's pretty simple. In 1985, they buy this vacation cabin for $75,000. The down payment is made with a $25,000 community property payment. Both spouses sign as obligors on the note, and title is taken as joint tenants. All of these facts establish the cabin as community property. That's the simple part. But now, let's get into the actions. The actions here are simple also, but the law that underlies them is a little bit more complicated. And here we see a subtle but clear crossover issue from the law of wills and trusts. Not because this is a wills and trusts question, but because the line item of community property law that's being tested here also is a potential issue on wills, and it's enormously helpful and valuable to distinguish the two bodies of law. So have a look at the actions. What happened is the husband inherits a bunch of money, and in two separate transactions, he improves the community property asset with separate property funds. Okay? It's simple. The couple is obtaining a marital dissolution. They're getting a divorce. And under a divorce scenario, the separate property will be reimbursed to the spouse that contributed it. So here, the husband contributes all this money to pay off the note and to build the addition. And since this marriage is ending in dissolution, he's going to get that money back. Now, suppose this marriage ended not by dissolution, but by death. What would the outcome be then? Would the husband's estate be entitled to claim that money back? Answer, no, because of anti-Lucas statutes that have been passed to avoid that result. So we reach the conclusion that the cabin is community property. Herb will be entitled to reimbursement of the $50,000 payment on the note and the $25,000 payment note on the home improvement. The rest of the value is community property, and it will be divided accordingly. And that wraps up a consideration of a simple, straightforward, yet legally intricate community property fact pattern. And I have no doubt that if you didn't know all of this law before you reviewed this question, you will know it now, and you'll know it when you sit for your bar exam.